Welcome everyone to the Judiciary Committee hearing this Tuesday morning. My name is Carl Rhodes. I'm chair of the committee. This Zoom meeting and YouTube live stream event will include just one agenda, our 9:30 hearing agenda. The other members of the Judiciary Committee are Vice Chair Keo Kaloli, Senators Ocasio, Gabbard, Lee, Kim, and Favela. As noted, this hearing is being live streamed on YouTube. You can find links to viewing options for all Senate hearings and meetings on the live and on-demand video page of the legislature's website. If you're interested in seeing the written testimony, you can go to the legislature's website, capitol.hawaii.gov, capitol.hawaii.gov, capital with an O. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business tomorrow, Wednesday the 23rd at 9 a.m. via video conference, and a public notice will be posted on the legislature's website. For those testifying on Zoom today, all testifier audio will be muted and video disabled until it's your turn to go. There is a 2-minute time limit on oral testimony, although in many cases members will have questions for you. So if you can hang around, that would be great. If there are temporary technical glitches during your turn to testify, we may have to move on, but we'll try to come back to you if we can sort out the problem. And we have read your written testimony as well. Okay, let's go ahead and get started on the first bill, which is SB 2043. SB 2043 is a housekeeping measure that repeals references to paragraphs in a statute that had been repealed. First up on SB 2043 is Gary Kam or Kristen Izumi Natao for the campaign space. Mr. Kam, how are you?
Hi, good morning, Chair, Vice Chair, members of the committee. The Commission has submitted testimony in support of this bill, and I will stand on that testimony. Thank you.
Thank you very much. Next up is Johnny May L. Perry in support. Members, any questions for Mr. Kam? Seeing none, thank you, Mr. Kam. We'll move on to the next bill, which is SB 2040. This is another housekeeping measure that provides that candidates are not required to file certain preliminary general reports if they are either unsuccessful or are elected to office in the primary election. First up for SB 2040 is Mr. Kam again.
Good morning again, Chair, Vice Chair, members of the committee. The Commission has submitted testimony in support of this bill, and I'll stand on that testimony. Thank you.
Thank you. Next is Johnny May L. Perry in support. And that's all the testimony we have on SB 2040. Members, questions? Seeing none, let's go ahead and move. Thank you, Mr. Kam. Moving on to SB 555. This requires, okay, so we posted an SD1 on this one, which would ban fundraising events from being held during any session of the legislature for sitting members of the legislature. First up on 555, that's the SD1, the proposed SD1 that we posted. First up is Mr. Kam.
Good morning again, Chair, Vice Chair, members of the committee. The Commission submitted testimony in support of this bill. We believe that this amendment will either prevent corruption or the appearance of corruption. And other than that, I stand on our written testimony.
Okay, thank you very much. Next is Gary Hoosier, Executive Director for Pono Hawaii Initiative. Good morning, Senator.
Yeah, good morning, Chair and committee members. I'll keep my testimony short. You have the testimony in front of you. I want to first of all thank you, Chair and committee and the entire Senate for the leadership on this issue. It's an important issue, and I'm in strong support with amendments to the proposed SD1, and they're important amendments. And I encourage you to look at what Virginia and other states have done. And it's not just stop fundraisers as terms of events, but it's to ban the solicitation and acceptance of campaign donations. As you all know, as we all know, there's fundraising happens in lots of different ways, from direct solicitation by phone, by email, by text, and social media. And simply banning an event will not prevent the fundraising to stop. It won't make it stop. So to give it teeth, to make it meaningful, I strongly encourage you again to insert the words acceptance and solicitation into the bill. And with that, I'll stand on the rest of the testimony and I'm available for questions if needed. Thank you.
Thank you very much. Next is Sandy Ma, Executive Director, Common Cause Hawaii. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We support SB 555, proposed SD1. We think this is a necessary measure to restoring trust in our electoral process. We also suggest some amendments. We suggest that this bill be amended to prohibit receiving contributions or depositing contributions during the legislative session, and also using any contributions of money that was not deposited prior to the legislative session. Maryland, where I lived for a number of years, has that in their statute. And we also think that this committee should consider applying the prohibition to every statewide elected office. Thank you for allowing Common Cause to testify in support of the proposed SD1, SB 555, and I'm available for any questions. Thank you.
Okay, thank you. Next is Russell Ruderman.
Present, Chair.
Former senator in support. Next is Kinkoko Iwamoto, President, Chamber of Sustainable Commerce. Good morning.
Good morning, Chair. Thank you so much for hearing this important bill and pulling it out from last year's lineup. Yes, it's so important. Thank you. As many of you know, 90% of people who responded to the Star Advertiser poll recently felt that this pay-to-play corruption that was recently exposed was just the tip of the iceberg and not as rare as we hoped. This is an amazing opportunity for the legislature, for its leaders to show what the Senate is made of, and stand strong in both prohibiting fundraising, but as was mentioned by other testifiers, making sure that we also prohibit solicitations as well as accepting donations. Senator Hoosier mentioned Virginia, but in fact there's Georgia, Nevada, Tennessee, Texas, Utah, and Washington. All of those states explicitly prohibit soliciting and accepting contributions during legislative session. And that is a huge loophole. While I appreciate banning a fundraising event, I could imagine that one of a wily senator or legislator might actually turn around and say, well, send a letter to all of their supporters saying, we're prohibited from throwing a fundraiser, but we can't stop you from making, a contribution, hit this button right here or mail in a check. And those communications could go out in key points in the legislative session. Clearly, that's a huge loophole. I'm sure you're not trying to leave open. So I hope that you consider amending your proposed draft. Thank you so much.
Thank you. Okay, next we have Kat Brady for Community Alliance on Prisons and support. Scott Foster for Hawaii Advocates for Consumer Rights and support. We have Neil Fraser for Fraser France Family Huey in support. Marilyn Yamamoto for Hawaii Family Advocacy Team in support. Melinda Carroll for When We Shine Foundation in support. Beppy Shapiro for League of Women Voters Hawaii in support. John and Rita Shockley for Free Access Coalition in support. Joseph Cohn, MD, We Are One Inc. in support. And Frederick, Executive Director, testifying for Hawaii Alliance for Progressive Action in support. Lila Moore for Kakua Council in support. Then we have 82 individuals, 81 of whom are in support and 1 with comments. And that's all the testimony we have on SB 555. Members, questions? I'll start out. Ms. Ma, can you come back up? So my understanding is your testimony was that you don't think it should apply only to the legislature and that it should apply to all other elected offices. What about
statewide? Sorry, statewide elected.
Statewide meaning, I'm sorry, the governor and the lieutenant governor, or you mean like city councils?
Governor and lieutenant governor.
Okay.
You, sorry for interrupting, Chair. Yes.
No, I was just trying to figure out where you're going with it because they're not in session exactly, and I don't know. And they have no control over the governor can't make me put a bill on the agenda, for example, or take it off. So why would we want to cover them?
We are concerned with perhaps, I do not know, perhaps if the governor decides to run for federal office per se, and the governor can accept donations during state legislative session. And so we are concerned about a possibility of governor vetoing legislation or trying to influence legislation in the hopes of running for federal office. And I'm not saying that's happening, but we have seen that in other states.
But the vetoes generally occur. I mean, the veto deadline is well after the session is over.
But the governor can influence legislation that way to talk about.
Okay.
Thank you.
Okay. Thank you. Members, other questions?
Yeah, I think,
yes,
I
sir,
got a
Senator
question, I
Malama,
guess,
go ahead.
in general, I guess. So this is for January to May. Is that what they're saying in this bill during session?
Whenever
January to May.
we're in session. So it could be special session, but yes, generally it's just January to May or early
And
May.
is that from 8 o'clock in the morning to 4:30, or it's when you finish work at 4:30?
No, it's gavel to gavel. So it's gavel of opening day to gavel of sine die. We would not be allowed to have fundraising events.
Well, the reason why I bring that up is because so you're saying anybody that's finished work at 5, 6 o'clock in the evening cannot do anything. It would be under this law. So as lawmakers, we're going to be prevented to not do anything in our spare time during session because a few individuals got penalized for doing stuff. Because I heard earlier, Chair, and I want to bring this up, money and campaigning doesn't cause corruption. The individual themselves cause corruption. Yeah, so the opportunity of corruption can't even have a price on it. Corruption can come at any time. It doesn't have to be money. It doesn't have to be a vote. It doesn't have to be campaigning. So I listened to this all of this stuff, and I'm for the bill. Don't get me wrong. But the bottom line is, this is not going to prevent corruption, Chair. And people have special interest that wants to give the money. If somebody's interested in taking and receiving this money, there's nothing any bill, any law is going to affect of these guys are doing them. Because we had provisions before, not taking gifts, and a lot of changes in legislation. I'm new to the whole process, but you try to tell somebody who's an elected official, now you want to do governor, lieutenant governor, who's an elected official, who's chosen by the people, that you cannot do nothing after hours into gavel to gavel. That's really pushing the limit in a sense of trying to say that everybody's corrupted now because of this whole situation. And that's sad to set a precedence in Hawaii that we try to label all our legislative officials under one incident or couple incidents has nothing to do with me and you and anybody else in this building. But like I said, you guys go with this bill, I want me for the bill. And I think him telling me what I can do at 6 o'clock p.m. when I'm not in this building, because it's gavel to gavel, I think that's really infringing on our constitutional rights of what we do as a individual outside of this building. Thank you, Chair.
Thank you. Members, any other questions? I did have one for Senator Hoosier, if you don't. Oh, I'm sorry, Senator Lee, you have your hand up?
Oh, no, thanks. Just one
Yeah, go ahead.
for Common Cause. You know, just reading through your testimony, and you sort of brought this up also, not just focusing the legislation on fundraising, but just any solicitations or acceptance of funds, period. Other states that do that, Alabama, for example, I'm reading right now, provides that candidates for legislative and statewide offices and their campaign committees may not accept, solicit, or receive contributions during the period in which the legislatures convene in session. So it applies to all candidates, I presume, to maintain a fair playing field. Is that what you're suggesting here?
Yes, we are fine with that too.
Okay,
Thank you.
thank you. Thank you, Chair.
Also for Senator Hoosier, if you're still here, hey, there you are. Well, as you know, the legislative calendar and the political calendar overlap in election years. Normally, I mean, this is a weird year because of redistricting. But we haven't been, no one's been able to pull papers to run for office. And we won't be able to for about another week. But normally by February 1st, people are pulling papers, including incumbents and everybody else too. So your proposed amendment to just say you can't take any money during session at all. I mean, I realize that incumbents have certain advantages that non-incumbents don't, but if we can't take money at all during an election year, when we have, because we've moved up the primary to July the ballots come out in July, that leaves, part of May, June, and half of July to run your whole campaign and raise all your money. And is that a realistic expectation of running a good campaign?
That's a good question, Chair. Thank you. I believe that incumbents have a huge advantage any way you look at it. I mean, a huge advantage. If you look at the bank accounts of incumbents, especially the chairs, you will see the vast majority of them have I want to say plenty of money, but certainly they have sufficient funds that far exceed those of a new candidate. They have the name recognition. They have they just got such an advantage already. And I believe that people in a position of decision-making should not be allowed to solicit money or accept money from those entities who are being impacted by those decisions. New candidates aren't in that position. They're not. And so I believe it's reasonable and necessary to focus on those in a position of decision-making when they're making the decision, which is during the legislative session. I have done a bit of fundraising, as you all know, and myself in the past, as in my political office. And professional fundraisers will tell you, don't have an event, don't have a fundraiser, just call people. And that's how you raise money. That's how you really raise money. You just call people that give money to candidates. And so this will not prevent what it's intended to prevent. And I applaud the committee and you, Chair, for putting this forward. But unless you prohibit solicitation and acceptance, it will still allow committee chairs and others who are pending a vote on an issue from calling the people impacted by that issue and asking them for money. And they're in a position now to feel like they have to give money. It's like extortion, even if it's not intended. But thank you.
Thank you. No, but I mean, the donors, of course, are strategic in the way they donate too. And don't you think, well, I guess the question is, from your experience, is when you have a date certain, you say, when you say, we're having a fundraiser on such and such a date during the session, and I'd like you to give some money by that date. My impression is, and you may or may not agree, but my impression is that it's a lot easier for a donor to sort of, if they don't really want to donate, they can sort of weasel out of it when it's not a specific date like that. So like the question is, do you think are you arguing that there's no difference in different kinds of fundraising?
Well, there are differences, but I don't think it's the job of this body to think of ways to make it easier to fundraise. I think we need to keep an eye on the prize of money and influence. Well, there's some states that ban it 30 days before and 30 days after the session. This would not be the strictest in the nation.
No, but there are also legislatures that meet year round. So
right.
If we met year round, when would incumbents fundraise if we had a rule like this?
That's true. I agree. As Senator Favela said, I think, or was saying that there are a few instances which shed bad feelings or bad appearances on everybody, and there are no shortage of those examples, and the legal examples, Chair. I'm talking of people that have almost $1 million in their bank accounts when it only costs $100,000 or so to run a campaign or less. There's many examples of that. I shouldn't say many examples of the $1 million, but many examples of excess funds in campaign accounts that aren't needed. And again, it comes back to influence. I believe if you're in a position of influence, you should not be asking people for money.
Who of us gets to, which of us, who gets to decide for another candidate whether they have enough money or not? I mean,
That's true. No, I agree. As the law is written now, they're allowed to do that. And I understand it's legal. I would argue that there should be caps on that also. But right now, I think the point is banning people from soliciting money when they're in a decision-making process, potentially affecting those people giving them money.
okay. All right. Thank you. Thanks for
Thank you.
your testimony.
Thank you.
Members, any other questions? Okay,
Chair,
if
one
not,
more.
oh,
Sure, sorry.
yep, sir, go ahead, Senator Favela.
Totally agree. But the question that I have is that throughout the years, since I'm still new to this, and every once in a while, an organization has nothing to do with any bills, have nothing to do with anything that's on the docket, but they just like what I'm doing, and they send me a check out of the blue, not even soliciting it. By passing this, I would have to return that check. They write in a letter, and we like what you're doing, here's $100. Now, because of this law. So that's the reason why I'm saying, and earlier part I hear you talk about how candidates easy to fundraise, and I agree with Senator Rhodes. You give a short period of time. Now, I'm just gonna bring this up because there's no news to everybody out there in the Zoom world that it's not as easy as an incumbent Republican candidate to go out and solicit funds, even if you're a Republican candidate, because a lot of the stigma about the party or the person that's running as an R doesn't attract the kind of money that everybody talks about. So I'm hearing about these millions of dollars and all of these kinds of stuff, whoever get blessed to have that kind of money. But you guys, not you, Senator Rhodes, but a lot of people out there think it's very easy to just, because you're an incumbent, money just falls out of the sky. And I can tell you right now, I've been doing this for 10 years and money just don't come out of the sky without hard work. So that's the part that I have a little bit. I want to keep everybody honest, Chair, keep everybody around the board, but you cannot put all of us inside the same bundle of fundraising, because each of us have their own talents on how to get funding. By saying that all of us is influencing people to donate to a campaign who definitely being part of the 16 committees, you think I would have $1 trillion in my account. But that's the part I'm trying to explain. It has nothing to do with how you fundraise or when you fundraise. It's just how you're going to use the money and your time. But because of this instant that this whole state is in an uproar about our colleagues that had gotten into trouble of the money thing, everybody's in the same basket. And I think that's shouldn't be true. If that's the case, then we should do that across the board for everyone then. Federal, state, city, elected officials, to any board. For neighborhood boards, to police commissions, to everything, right down the line. Even if you're gonna get a ticket for a fundraiser or a $10 plate lunch, then everybody should be across the board. And I just don't think we should all be in the same basket, Chair. That's my dilemma on this bill. Okay, thank you, Chair.
Thank you. Any other questions or comments on SB 555? Okay, if not, thank you everyone for being here. We'll move on to SB 3329. This amends the scope of chapter. This is it's called a SLAP, an anti-SLAP legislation. SLAP meaning strategic lawsuit against public participation, where generally big money interests sue you to keep you quiet because they know it's too much hassle to defend the lawsuit. So first up on SB 3329 is Lane Shetterly, Commissioner from Oregon for the Uniform Law Commission. Oh, there you are.
Yeah.
Good morning.
Good morning. Thank you, Mr. Chair, members of the committee. My name is Lane Shetterly. I'm an attorney in practice in Oregon and a member of the Uniform Law Commission from Oregon since 2005. Speaking today in support of SB 1 to your Senate Bill 3329, which would adopt the Uniform Public Expression Protection Act. A SLAPP suit is a suit that is brought to silence or intimidate citizens by subjecting them to costly and lengthy litigation for having done nothing more than exercise some constitutionally protected right. An anti-SLAPP law is designed to protect defendants from the abusive effect of a SLAPP suit. More than 30 states have adopted some version of an anti-SLAPP statute. Some of the older statutes are narrowly drawn, designed to protect persons under limited circumstances, such as from statements made in testimony in front of a planning commission or zoning board. Hawaii's current anti-SLAPP statute is of that narrow variety. Other more modern statutes are more broadly written, covering constitutionally protected speech and conduct in a wide variety of circumstances. The Uniform Act advances this modern trend. Given the rise in social media and the internet, plaintiffs often have the ability to choose their forum for filing a SLAPP suit, and will do so in a state that either doesn't have an anti-SLAPP law or only a narrow one. This subjects citizens to not only having to defend a meritless SLAPP suit, but having to do so in some state with which they have no relationship. That is why the Uniform Law Commission determined that a uniform law was called for to level the playing field of protections for those who might find themselves victimized by a SLAPP suit. A SLAPP suit gives a party against whom anti-SLAPP law gives a party against whom a SLAPP suit has been filed the opportunity to get the case dismissed early, and if successful, allows them to recover attorney fees. In that way, it both deters the filing of SLAPP suits and provides meaningful relief to a party against whom a SLAPP suit has been filed. Very briefly, I want to address a question.
I'm sorry, your time's expired.
All right, Mr. Chair, happy to answer questions if the opportunity comes up. Thank you so much.
Thank you very much. Thanks for zooming in. Next up is Elizabeth Kent for Commission to Promote Uniform Laws.
Aloha.
Oh, there you are. Good morning.
Good morning. Thank you for the opportunity to testify in support. I believe that robust public participation builds a strong community, and I'm also a big fan of the First Amendment, and I urge you to support this uniform law. Thank you.
Thank you. Next up is Denise Antolini, President for Malama, Pupukea, Waimea. I think that there's something else there. I don't know what it is. Anyway, go ahead.
Good morning, aloha Chair Rhodes, Vice Chair Kiokalole, and the rest of the committee. It's a pleasure to see you. As you know, in my working capacity, I'm a law professor at the law school, and I have over my career studied SLAPP laws. But in my private capacity, I'm the volunteer president of Malama, Pupukea, Waimea, up here on the North Shore. And our little organization was involved in a lawsuit challenging a developer's permits, a typical public interest lawsuit, and we were slapped for $13 million in the last about 2 years ago. We tried to use Hawaii's anti-SLAPP statute, and the judge found that it was too narrow to protect us. That case is over. The SLAPP claims were dismissed with no dollar amount, so they were meritless. However, we vowed to, in the greater public interest, try to fix Hawaii's anti-SLAPP law because it's not working. The uniform law is a gift at the right time for Hawaii, and to be able to join with other states to achieve some uniformity across the board with broad protections is a really unique opportunity for us to move forward from our 2002 version, the old clunker, to something that would be like the electric car version for protecting uniform expression. So I urge the committee to seriously consider the proposed SD1. I thank you for adding it to the committee's agenda, and appreciate your support and happy to answer any questions. Mahalo.
Very much. Next, we have John Wookie Kim for the ACLU of Hawaii in support, Douglas Miller, Legislative Committee, League of Women Voters of Hawaii in support, Lauren Blickley for Surfrider Foundation in support, Wayne Chung Tanaka for Sierra Club of Hawaii in support, Benjamin Sadowski for Unite Here Local 5 in support, Ben Scheffner, Senior VP and Associate General Counsel for the Motion Pictures Association, Inc. in support, Ted Boland for Climate Protectors Hawaii in support, Sandy Ma, Executive Director for Common Cause Hawaii in support, Hawaii 1000 Friends in support, Max Phillips, Hawaii Director and Staff Attorney for Center for Biological Diversity in support, Evan Oya, testifying for Hawaii Association for Justice in support, Winston Welsh, Executive Director for the Outdoor Circle in support. And in addition to that, we have 5 individuals all in support. Okay, members, that's all the questions we have on all the testifiers we have on SB 3329. Members, any questions? Let's see, hang on a second here. So,
Chair Rhodes, while you,
oh, go ahead. Go
I
ahead.
was going to say, while you're taking a minute, is Ms. Antolini still with us?
Yes, Senator, aloha.
Thanks. I was just going to fill time, but who's the developer, or what was the? Are you able to reveal that?
It's public information. I'd prefer not to say because I think that's a bit of a distraction from where we're headed. But I can say that our case was not unusual. So as you know, the public interest community statewide is often engaged in litigation challenging permits. It's a very normal kind of procedure that's provided for by law. So the case wasn't unusual in that respect.
Understood. Thank you. Thank you, Chair.
Thanks.
Thank you. Mr. Shetterly, are you still here? Yeah, there you are. So if you can remember, you said that you had a summary or some salient point that you wanted to make, and I would be interested in hearing what that was.
Yeah, thank you, Mr. Chair. This addresses Section 7 of the bill. In preparing for the testimony today, a question came up just about how this works. And the way it works is a party who files a SLAP motion submits that, and then the responding party, which is going to be the plaintiff, the party that brought the suit, has to respond to that motion by showing that they have alleged at least a prima facie case. That is, they've alleged all of the required elements of the cause of action. That tests the sufficiency of the basic allegations. What happens then is the party that filed the anti-SLAP motion can nevertheless show that even though all of the legal requirements of the elements have been pled, that there may be a legal defense such as statute of limitations or some other statutory defense that defeats the claim, even though it may have been properly pled. I just wanted to make it clear that the court in this case does not weigh evidence. The court uses what we call the summary judgment standard in looking at whether there is a genuine issue of material fact and whether the party seeking the dismissal of the action is entitled to judgment as a matter of law. Just clarifying that this act does not call for courts to weigh evidence, but instead applies a very familiar standard summary judgment standard of determination.
Okay, thank you very much. Members, any other questions? If not, testifiers, thank you all for being here. We'll go ahead and move on to the next bill, which is SB 3164. This requires the maintenance of transfer records relating to certain campaign contributions and transfers. First up on 3164 is Gary Camphor, Campaign Spending Commission.
Good morning, Chair, Vice Chair, members of the committee. The commission is in support of the intent of this bill, but we are asking that this bill be held by this committee. We believe that instead of having a model act and just putting it in Chapter 11 as a new subpart, I think we need to explore. Well, number one, we need to explore the nature of the problem that that this bill is supposed to address, and especially to discuss that problem in the context of Hawaii, what's happening in Hawaii, and then look to ways that we can amend. We currently have a disclosure requirement section for non-candidate committees. We should see if we can amend 11-355 to get the information that this bill seeks. So we would ask that this bill be held, and I believe there is a House bill that is moving concerning dark money that does that doesn't go as far as this bill, but it does try to make amendments to Chapter 11, which I think would be preferable to taking a model act. And I don't even know if this act has been adopted in any other jurisdiction. I mean, I guess that would be helpful, and then we could see their experience with working with this kind of language. I'm available for questioning, and I'll just stand on the rest of the written testimony. Thank you.
Okay, thank you. Next up is Sandy Ma, Common Cause Hawaii. Morning again.
Good morning, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We do support this bill, SB 3164, and we do think it's necessary in Hawaii to bring more transparency in our election ads. It does this by requiring anyone who acts as a conduit of $10,000 or more in a 2-year election cycle, election period, to keep track of large donations it receives and disclose where this money comes from. And it discloses down to the original source of the funds. So we do think this is necessary. And we are willing to work with the stakeholders, this committee and Campaign Spending Commission to propose amendments to this bill to make it more satisfactory to this committee and Campaign Spending Commission. We are working on amendments as we speak. As for the other House bill that Campaign Spending Commission alluded to, we do have serious questions as to that other House bill, as it only affects C4s and nonprofit C4s and doesn't affect any other entity. And this bill actually impacts all election ads, not just those produced by C4s. And I'm available for any questions. Thank you for allowing me to talk very fast about this bill. Thank you, Chair, members of the committee.
Thank you very much. Next is Aaron Mckean, Legal Counsel for Campaign Legal Center. Excuse me. Morning.
Good morning. Thank you, Chair, Vice Chair, and members of the committee. My name is Aaron Mckean, and I am Legal Counsel with the Campaign Legal Center. And we're also in support of SB 3164 because it does provide that comprehensive bill for ensuring that Hawaii voters have more information about the wealthy special interests who are trying to influence their vote. We've provided written testimony in support of this bill, and I'm happy to be available for any questions. Thank you for the opportunity to testify today.
Thank you very much. Next, we have Beppy Shapiro for Legal Women Voters in support, Barbara Polk in support, Johnny May L. Perry in support. That's all the testimony we have on SB 3164. Members, questions? Go ahead, Senator Ocasio.
Question could be for Sandy Ma, or it could be for, do you think that the 10,000 is sufficiently low enough, or is this or is it a bit of a compromise?
Excuse me, Senator, was that for me or for
yes.
Campaign?
Yeah. Oh. Yeah.
Thank you. Sorry. Yes, we arrived at the $10,000 threshold based on U.S. Supreme Court decisions. So we do think that that is a defensible spending limit. And we do know that for ballot initiatives, that there is large quantities of spending. And so that does trigger that amount. Thank you for that question.
Members, any other questions? If not, I have a question for Mr. Cam. So in your testimony, written testimony, you said that you thought it would be useful to convene a panel of experts, practitioners in campaign spending law, and get recommendations for the legislature's consideration. I mean, how long will that take? I mean, weeks, months, years, decades? What are we talking about?
I don't think it took longer than a year when the last time Blue Ribbon panel was convened. That was slightly before my time, so I wasn't involved in that. So I came on board a year after the recodification, but it didn't take that long.
Is there any formal process in place at the moment?
I don't think there is a formal process.
But as far as you know, there was one 10 years ago or 12 years ago when the recod happened?
Yes.
Do you remember whether that was by a reso that we passed or a bill that we passed, or how did that come about?
I don't know how that came about. I just know that it was done, and then the recommendations that were made by this panel then was brought before the legislature.
Is it something that you can do informally? on your own, and the Campaign Spending Commission can do informally on its own initiative?
I believe so. I mean, it pertains to our statute. Basically, every year we go through a process of determining, what would be amendments that we would like to see passed or what needs to be repealed. So it's part of the process. It's just that this one would involve outside attorneys who represent non-candidate committees who practice in this area, who have to deal with, just like the commission, they would have to deal with the day-to-day language that being sought that's being sought to be put into our statutes. And we just believe that we do have a law for disclosures for non-candidate committees, and we believe that if we can use that as a starting point, rather than something that's totally alien to our Chapter 11, I think that'd be a better approach.
Okay, thank you. Members, any other questions? Okay, if not, thank you testifiers for being here. We'll move on to the next and last bill on this agenda. It's SB 2046. This amends provisions relating to dates and deadlines and statutory provisions regarding political parties. First up is Scott Nago, Chief Election Officer. Morning.
Good morning. Good morning. The Office of Election stands on its written testimony and support, and we'll be happy to answer any questions.
Thank you. Next is Michelle Tippins for the Libertarian Party of Hawaii in support of one part and opposition to the rest. And Johnny Mae Perry in support. That's all the testifiers we have in SB 2046. Members, questions? Okay, thank you, Mr. Nago, for being here. I don't have any questions either. Members, unless you want to go to a breakout room, I'm ready to start making recommendations for voting.
Can we go to a breakout room?
Yep, of course. We'll be in recess for a little bit and back for the vote shortly. Recess. Okay, back in out of recess for the 9:30 agenda for decision making. First up was SB 2043. This is a housekeeping measure that repeals references in a couple of sections to a statute that's been repealed. Recommendation is to pass as is. Questions or concerns? If not, Vice Chair.
Members voting on SB 2043, the chair's recommendation is to pass this measure unamended. Chair Rhodes?
Aye.
Vice Chair goes aye. Senator Ocasio?
Aye.
Senator Gabbard?
Aye.
Senator Kim?
Aye.
Senator Lee?
Aye.
Senator Favela? Senator Favela?
Aye.
Chair, recommendation adopted.
Thank you, members. Next up is SB 2040. This is another housekeeping measure that provides that candidates are not required to file certain reports if they're either unsuccessful or are elected to office in the primary election. Recommendation here is to pass as is. Questions, concerns? If not, Vice Chair.
Members voting on SB 2040, the recommendation is to pass this measure unamended. Noting the presence of all members of the Judiciary Committee, are there any members with reservations? Any members in opposition? Seeing none, Chair, all members vote aye. Recommendation adopted.
Thank you. Next up is SB 555. The proposed SD1 would prohibit fundraising events during session for members of the legislature. Recommendation is to go ahead and adopt the SD1 as it was posted. This is not a silver bullet. It is an important step, I believe, in delinking our fundraising activities from our legislative activities. But to my liberal friends who want to go farther, I understand your impulse, but there are complications when you go farther because of the way the election cycle and the legislative calendar overlap. And I would just say, please don't let the perfect be the enemy of the good. This is a good bill, and I think we should move it forward. Members, questions or concerns? Senator Ocasio.
I just wanted to say thank you to Senator Rhodes for hearing this measure. I know it's quite complicated. There are potentially different unintended consequences depending on how each individual legislator goes about their process for raising funds as well as even the nature of whether one is a chair or not a chair. I do actually support this 100%, and I think it's really important to level the playing field when it comes down to having our money and politics and potential corruptions and power differentials when it comes to hearing bills. I do support actually the suggested amendments of having contributions in general being banned, and I know that that's not what is currently in front of us at this point, but I did just want to say that because the appearance of impropriety, but then also the actual power differential that it does create is really important. I would limit it at this point just in certain details to the legislative session, the regular legislative session, because as was noted, a campaign could decide to have a fundraiser and then we go into special session, and that would conflict with a date that's already been prepared for. But at any rate, thank you, Chair Rhodes, for hearing this bill. Very important.
Thank you. Members, any other questions or concerns? If not, Senator Keohokalole for the vote.
Members voting on SB 555 SD1, the chair's recommendation is to pass the SD1 unamended. Again, noting the presence of all members of the committee, are there any reservations? Are there any no votes? Chair recommendation adopted.
Thank you, members. Next up is SB 3329. This amends the scope of chapter. This is the SLAP suit one, which is a strategic lawsuit against public participation. This is an anti-SLAP suit bill. Recommendation here is identical to the last recommendation, which is to accept the proposed SD1. So that would be the amendment, the proposed SD1 with no further amendments. This would update the current law that we have, and I believe it will be more effective in dealing with so-called SLAP suits. Questions or concerns? If not, Vice Chair.
Members voting on SB 3329 SD1, the recommendation is to pass this measure unamended. Are there any reservations?
No, it's an amendment. It's accepting the SD1.
Right, I announced it as a SD1. So,
I'm sorry. I thought you said unamended.
So noted on the recommendation. Members,
Just-
are there any reservations to the chair's recommendation? Any opposition? Okay, seeing none, Chair, your recommendation is adopted.
Thank you. Sorry for the confusion. It's my fault. SB 3164, this requires the maintenance transfer records relating to certain campaign contributors, and transfers requires certain covered persons to seek permission from contributors to use transferred contributed funds for independent campaign spending. CSC, I understand their concerns. I would like to go ahead and move it forward, and hopefully we can do something sooner than later to sort of adapt this to Hawaii law, but if not, we'll try again later, maybe. We'll try again later if we can at some point. So there will be text and then a defective date of July 30, 2075. Questions or concerns? If not, Vice Chair.
Members voting on SB 3164, the chair's recommendation is to pass this measure with amendments. Are there any reservations or no votes? Seeing none, Chair, recommendation adopted.
Okay, thank you, members. Next up is SB 2046. This amends provisions related to dates and deadlines and statutory provisions regarding political parties. Recommendation is to pass unamended. Questions or concerns? If not, Senator Keohokalole.
Members, I'm sorry, that was with amendments?
No, unamended.
Amended. SB 2046 passing unamended. Are there any reservations? Any no votes? Chair recommendation adopted.
Okay, thank you for everyone for being here. We're adjourned.